Hello, everybody. Excited utterance here. My name's Hella, and justice for Sarah Boone. You know what's interesting? You know what's interesting? What's very, very interesting is that Sarah Boone is doing quite well in court. Huh. Isn't that interesting? She's doing quite well as her own lawyer. Well, pretty well for a first timer, considering she has no experience and no training, and she doesn't even want to be her own lawyer. And you know what? Also, the normies over on Law and Court Chat, Court TV Chat, in fact, just about everybody who hates Sarah Boone, and that's most of the US, they're getting big mad about the fact that she's doing pretty well. And she's also being quite respectful in court. So how boring is that, everybody? Everybody wanted her to have big tantrums in court, didn't they? Everyone was like, whoa, this is going to be so entertaining. She's going to be so annoying. She's so entitled. She's so this. She's so that. She deserves it. No. Well, look at her now, showing everybody up. Now, don't get me wrong. I don't think that she should be representing herself, but she's making the best of it. She's making the best of it. She's being a good girl, trying her best. Couple of little snarky comments every now and again. She asks sometimes what that means. She says, sometimes I don't understand. She asks the judge to repeat himself from time to time. She doesn't know what she's doing. But I gotta say, she's getting some wins in. She's getting some wins in the courthouse. Alrighty, hello everyone. Flash fan, how's it going? Young, unchain my heart. Yeah, motion to unbound my love. Indeed. And also, hello John. Good to see you. And Christine, good to see you too. Let's bring in my favorite co-host. My favorite one.
Hey.
Hi.
Hi.
Because I've got other co-hosts, I'm just hiding them from you.
I knew she's cheating on me.
I have plenty. There's tons.
I know.
It's all good. Ah, dear. And
I'm
by the
nice
way,
co-host.
I put into chat, I have another little side project going on. When I say side project, I mean I have someone else that I think needs justice. More justice. And
Mark
that
Jensen.
is no. He's had plenty of chances at justice. I think justice has been served for Mark Jensen, actually. No, I think Miss Corey Richards, she's being screwed over by the courts.
Damn
so
straight.
We're going to be doing some streaming on her because her Sixth Amendment rights have been shat on, in my opinion. But everyone thinks she's guilty because we've only ever heard the state's case on this. In fact, we haven't even heard just the state's case. We've heard all the victim impact statements already.
Yes,
we did. We heard everyone from the family all telling us exactly how terrible she is.
Yes.
Early on, right at the arraignment stage, I think it was, because that's how it works in Utah. So anyway, that's her. Let's move on from her, though. Oh, hey, Harp Irish. That's okay.
Hey.
That's all right. Okay, let's get into this. And Ronnie, hey. Okay, let's get into this because we have the hearing from yesterday. Was it yesterday your time?
Yeah.
Because today's my Sunday.
Yep.
All right. Okay. So, and happy birthday to Mr. Potentially Criminal. No, not you. To Mr. Potentially Criminal. It's already past his birthday for me, but it is his actual birthday today. So, hello to Sean. You don't know much about Corey Richards? Well, don't search it up. Yeah, she's hot. Don't search it up because everyone thinks she's guilty, but I have my doubts. We'll see. We should think she's innocent. She hasn't been to trial yet. We should think that. But hey, it's the US. It's the US. I'm learning this. People just go, oh, well, whatever court TV says, we believe that. Okay, let's go. I've got it on 1.25 speed. If it gets annoying, let me know. Also, it's quite loud. I found that it was quite loud. JMK is here. Oh, yes, Luna. Hey, Luna, good to see you. Yeah, I'm finding that it is the US, isn't it? And I don't know if I'm just picking and choosing, but okay. So the other day, Sean was getting really, really mad about Georgia, and he was saying, "Oh, Georgia's so corrupt. Georgia's this, Georgia's that." And I put a question in chat, and he was. I'm not going to say spurting out. He was going off so bad that he was not answering messages at the time. But I said, okay, question: which state in the US is not corrupt? Because I'd love to know. At this point in time, I'd really like to know which state has a really fair, honest, open justice system. Thank you. Someone tell me. Hey, JMK. How's it going? Okay, let's keep going.
Hit the play button.
There she is with her pink cuffs. And this is the main motion, the main point that's being made at this motion hearing is for her to be unshackled. And that was a great motion that she put forth, by the way. It's smart.
Free at last.
And when I say unshackled,
last.
I don't think she quite understood that she was going to be
unshackled,
free of movement, at least from the waist up, at trial, because she has to be, because there's going to be a jury there, and she's going to be in street clothes. She can't appear to be incarcerated at trial. But all these motion hearings leading up, especially considering she is her own lawyer now, it was a great motion for her to put forth to at least be able to write freely. She needs to be able to do her job as a lawyer. Otherwise, again, her Sixth Amendment rights are being violated if she can't even just write. How's she going to do her job effectively? So, great motion there, Sarah. All right, let's go.
Aw, she got a pen.
Yeah, good morning. If you raise your right hand, Madam Clerk will swear you in.
Not really, Your Honor.
How's the sound? I've got lots of background feedback. Just give it a sec to even out.
Okay.
Oh, that's different.
The court
Okay.
entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right.
Is it
I know
better?
you had brought up concerns regarding mailing, and I just wanted to go through the historics with regards to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Kirschman's motion
She
to
can't even
withdraw
flip
and
through the
addressed
paper.
your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy of that order. On May 25, we had a hearing and an order was entered and a notice of hearing was set. That order was hand-delivered to you. Thereafter, there was an order setting hearing that was entered on July 29. That order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also
I understood it half Irish. We will talk about that. The thing about her opening the files.
Response to motion seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with address to you, your inmate number, FDC Dorm B, P.O. Box 4970, I apologize, P.O. Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
Did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th.
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address. We've been addressing P.O. Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so.
Okay.
For receipt.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the P.O. Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I have questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery. And that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original.
Still can't believe they had the wrong goddamn address.
Put that on record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to P.O. Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice. But I can tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Okay, guys, I need to pause this for a second.
Part of the order from Monday was regarding the state.
Breaking news, everyone. Breaking news. We have new correspondence from Sarah. Thank you, Darlie, for letting us know. Breaking news. Everyone, let everyone know. Snibbles, how are you? And Flashman, you said, I'm sure it was a simple mistake. At least they fixed it. Eventually. It's taken a bit of time, though, Flashman. Okay, we have breaking news. We have a new letter from Sarah just now. So I think we're first.
I just saw it on the court website.
You just saw it?
Yeah, I guess it was uploaded yesterday, but.
Alrighty, hang on a minute.
You want to present it? Or?
Actually, yeah, could you present it? Thank you.
Unos momentos. Oh, sorry, let me just open it again. It's basically just talking about the laptop issues.
It's about laptop times and stuff. So
yeah. So I think it's in reference to some of the stuff she mentioned today.
Can you share it? Oh, sorry.
I'm trying.
Oh, you read it early, beautiful, waterfall. Hello, good to see you, beautiful.
Oh, did you?
It's been there since yesterday evening. Has anyone streamed it yet?
Yeah. I saw it was uploaded yesterday. I just hadn't seen anybody mention it yet, but maybe somebody did.
Breaking news. I arrived. It's the captain of the jail. Okay.
Yes.
Thank you for that.
So.
How long is it? How many pages?
8 pages.
8. Oh my God.
We can kind of sum it.
Let's just get the gist of it. Yeah. Could you start, please?
Yeah. Can you see it?
Yep.
Thank you for your timely cooperation and assistance in receiving my laptop yesterday, 8/6/24, and 2 Discovery USB drives supplied by my investigator. I am attempting to fully maximize my opportunities available from OCCD to thrive in my forced position as court-appointed pro se defendant and the success of my case. Oh, she is eloquent.
Just a second, Brad. So she still has to handwrite letters even with a laptop.
Oh, yeah.
Why? Because she can't print out.
No printer.
Or could she email them?
No internet.
Because she got no internet. Are you for real? This is ridiculous. Why? Okay, so she's got a laptop and she can't send any files anywhere.
No, yeah. She'd ask for MS Word so she can start typing and printing.
I absolutely should give it to her. Thank you for being here, beautiful warrior.
Yes.
Waterfall, sorry. She doesn't have it. This is so stupid.
I know.
Oh, sorry, I'm just losing my shit now because this is it. What annoys me most about this is that people see this nice exterior by the judge and how he has this calming voice and it seems like he's helping her, but he's helping her on the surface. But then he knows full well that he's only giving her the base level of stuff, right? But something like a computer without internet or a printer is goddamn useless to her. Hey, Dr. Hines, how are you?
Good to see you, buddy.
This just drives me mental. Okay, keep going.
Okay. I want to excel in my present circumstances by attempting my best and have been since day one of my incarceration ongoing 5 years ago. As you can imagine, I do not want to be here any longer, ever. With the hopeful, effortless cooperation and attentive care from yourself and OCCD, I believe I can achieve more efficiently, effectively, equally, so I am able to plan my very overdue exit in the very near future. I have been instructed to contact you directly for the listed questions and concerns to hopefully remedy or provide further insight to for completion of. So there is a universal understanding to enable me to produce greater, faster results and work product in my case in defense. Thank you in advance and profusely. Laptop times extend from 8 a.m. to 4 to 7:30 to 10 I am willing and need to vigorously work on my defense as often as possible. I do not think I should be restricted to daytime use only. After 4 p.m., I do not have access to the laptop, which equals 0 work product and progress. The building of my defense is halted for 16 hours until the very next morning. Request: extend times to use by 2.5 hours in the evening. 2. USB drive security. As stated in court to the judge, I do not feel comfortable in handing over the entire contents of my case to the miscellaneous officers in the dorm for the day. All of my information is highly confidential, and I am trying to avoid further leaks on top of the already recorded jail phone calls. And I'm trying to get those visitation names and details, my inmate interaction, meals consumed, etc. Really? I can get a list of her meals consumed?
Oh, really?
It's a little specific, sweetie. Okay. A concerning example today. I returned the laptop and USB drives together yesterday. I received back the laptop, which is not charged at all for important use.
I knew this was going to happen.
We called it. We called
We
it.
did. We called that. We knew that was going to happen
Yes. Yes.
because it hasn't got a cord, and we knew that she'd give back the laptop. They wouldn't charge it up, and so it would be useless to her the next day.
Yep.
So what does she do? She loses the whole day.
I mean, assuming the
going.
guards listen to her and like go and charge it for her, and then yeah, she still loses 2 to 3 hours.
This is garbage.
And the
And of course,
USB.
like, hang on, like, wait. Also, when it comes to her Sixth Amendment right and to her appellate issues, they can't really blame anybody, can they? Like, because that's the jail doing it.
Yeah, I mean, there's no real easy record for that. I mean,
Yeah, like,
unless
because
she makes one like this, but even then, it's like,
oh,
okay,
well, no,
it's
hang
just
on. When it comes to appellate, like, she would get she's indigent, and she would therefore get an appellate attorney, right?
sure.
Yeah, okay. So an appellate attorney would look at this situation and go, okay, well, the court tried to provide her with a laptop, and then the jail just didn't facilitate it properly. Should the court have been able to foresee that?
Yeah.
Yes.
Yes, they should have.
Yes.
Yeah, they're state
Although-
employees.
You would think. This is ridiculous. And like,
I mean,
she's putting it in writing, though. She's putting this in writing, though. This is at court. This is on record. So
Yes. And she could be lying, but
doesn't matter if she's lying.
and quite frankly,
It
we
should be
said
looked
this.
into.
We said this would happen the day they mentioned the procedure, or I said this the day they mentioned the procedures, that she was going to have issues with the laptop being charged.
Yeah.
She was going to have issues
yeah.
with using the laptop because it's only going to last for 2 to 3 hours.
100%.
So yeah, I knew this was coming.
Yep.
And the
Yeah,
US sorry.
Well, she's writing the letter. It's on record now.
Yeah.
It's in the list of court documents.
It is.
So now, if this happens again and it comes to an appellate issue, then it should be able to be brought onto the record, surely.
I would hope she continues to make objections
To write the
like
stuff
this.
down.
Yeah.
Yeah.
I mean, as nutty as it sounds to people that will use it to mock her, I mean, something like this.
Oh,
needs
people
to
are going
be
to
noted.
mock this. People are mocking everything she says, and they say she just complains and complains and complains. She needs to complain.
Yeah.
She needs to
Yeah,
complain
that's
about
how-
every
yeah.
little thing.
That's what objections
She
are.
does. Yep.
You're complaining.
Yeah. Yep. No, let's keep going.
So I received, okay, and the USB drive separated with the protocol security paperwork retrieved I needed, and then both bags resealed. Another example, I went to pick up everything in the morning. Excuse me, sorry. And the officer retrieved both USB drives from the bags before giving to me. Who is in control of the laptop and my 2 USB drives when I return at the end of each day? Where do they go? How are they secured? Why are contents being removed? Opened? As said, I do not feel secure in this process. If there is one, and it is vital to me that OCCD handles with priority, safety, security, and care. When asking any officer anything pertaining to the laptop and drives, they do not know and become agitated with me trying to ask and figure anything out. Request. Allow me to keep only the 2 USB drives at my bunk after returning the laptop to keep in my secured locked drawer each day. Hopeful evening. And that's an awful idea, Sarah.
Well, but it's secured and locked. What?
I'm guessing it's, if she has a drawer that's locked, I'm guessing it's a really flimsy lock. And
No.
it's very easy for, I mean, that happened with Zach.
It's the best she can do. Like, what else can she ask for?
Yeah. Yeah.
This woman's desperate to be able to do this work.
Oh, yeah, she is. And to her credit, she
Yeah.
is trying to do it.
Yeah.
3, classroom. This room is unoccupied for the majority of each day and am available. Close, undisruptive solution for me to achieve privacy for reviewing and listening to my confidential case documents. The classroom is also in direct, continuous, effortless view of the officers at all times. This girl has to have a thesaurus. Request. Permit me access to utilize a table in the classroom to view and listen to my discovery on the laptop when not occupied and is in direct review of the officers.
She's right. She should have some privacy to do this. You okay? Do you want me to do this?
No, I can do it. Sorry. It's that time where you just start yawning
I
a
know.
bunch.
I know.
No, I'm fine. As said, my discovery contains a large amount of audio to be listened to. If you will not permit me access to the classroom, I will need listening abilities with earphones or headphones over the ever increasingly loud level of the dorm. These are also a must when the dorm is on lockdown and quiet, so no one is able to hear. Request, provide any kind of earphones or headphones stat. 5, internet with limited access and restrictions.
Yeah.
I need to research heavily my defense in all of it, locate witnesses, any experts, the clerk's website, correspond with the judge, my defense team, anyone affiliated or may be with my case, and Samsonite Corporation. Forward notifications, other important documents, everything I need to educate myself on about being pro se, etc. Please understand, I cannot.
They did give her that. So
packet,
you've decided to go pro se packet.
I cannot
That should be
complete
enough.
any. Yeah, right. I cannot complete any of the above mentioned without internet. The basic laptop provided is only for viewing my USB drives. There is no other access. Request. Permit me access to the internet with appropriate parental controls.
We should get that. Actually, you're right, half Irish. I'd love to see that packet. Let's get that packet.
Remind me about that.
The pro se packet. Yeah. We need
that.
Yeah. We need to get the Florida pro se packet.
I'm pretty sure it was young.
Has it been the burner suitcase with Samsonite? There was talk of a Samsonite expert a year ago when Bankowitz was the defense attorney.
Yeah.
Yes.
I'm still looking for the model number.
Although I don't understand because I thought all Samsonite ones were hard case and this one was not. But maybe they
No,
make it
I think
range.
Samsonite does. That's what I thought too. But Samsonite does
Yeah.
have some softer shell ones.
Well, there you go. Clearly they do.
Yeah, just imagine
Maybe-
I buy one and I can do some like scientific experiments like an expert.
Yes. Yeah, like an
see if I
expert.
can
Because
fit in it.
experts are just awesome. Yeah.
Yeah. I'll even get my sunglasses on and just go to town.
Rotating light.
To type any motions, make notes, lists, name, anything. I need to document and record for future reference or sharing with potential team members. I need to be able to open and create a document, save work product information, attach text or PDF documents created to email if granted. Print needed documents or discovery pages for mailing, sharing, presenting, or distributing. Request. Permit access to Word program to use fully, properly, and progressively. 7. Telephone access. As you are aware, my dorm contains pay phones. can't even call 900 numbers, only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular normal phone to make any call necessary.
Can't
Or
argue with her.
to make any / all necessary calls for my case to use in Trill. I have no other way to contact anyone that is not collect, which incredibly diminishes must, if not all, of my opportunities to properly prepare. Permit me access to a regular, normal phone to communicate reasonably with the parties in my case, and any new futuristically to be affiliated with.
Futuristically is her favorite word. I know. It's
Yeah.
a very silly word.
Is that a real word?
Well, yeah, but not. People don't use it in daily life. Like,
Nobody uses it, but like, does that actually exist though?
I think, but yeah, it's
Okay, no, in a way that is strange and very modern or seeming to come from an imagined time in the future.
that's not what it means. She's talking about like,
It's funny though. I mean, not like it,
yeah.
I do
it's
like her
not-
vocab. I will say this: her
Her
vocabulary
vocabulary
is
is good,
amazing.
but that's
She
not
is-
what she means. She just
No, but-
means in the future.
I just love her vocabulary.
Yeah.
Futuristically, I just love it. Discovery hard copies, as I am presently. I can keep these in the permitted property bag discreetly located at my bunk. Gosh, why am I keep yawning? Sorry. I will purge the documents I have new and keep only my discovery hard copies. The remaining I can send to the proper department and will purge anything already being stored for easy convenience and extra space. Also, when the laptop hours are closed, I'm able to pick up uninterrupted with these hard copies at any time. Any comparative review with the digital can also be achieved. Permit my hard copy discovery to be received and kept unnoticed at my bunk for needily available viewing and unrestricted access to.
Did she make
Needily.
any actual further points that are worth listening to?
Well, I'm just listening for her vocabulary.
Okay.
My attempts are always in good faith. That's
What
more
else
than
is she
most
asking for?
lawyers. No, this is just the summation of it all.
Okay.
Oh, there's a PS. I also spoke to Sergeant Casey in the courtroom, requesting your time, please, at your earliest opportunity to convey the importance of my request to hopefully be completed. Rawr.
Okay. So, all right. So she's asking basically for a laptop that works, that people don't keep like interfering with, that has
Pornhub.
programs on it that work, a printer, some headphones, and internet access that's not like complete internet access. She just wants like parental controls on it and stuff, a phone that she can use, a little bit of privacy. That's it.
Pro se, yeah, you're right, beautiful waterfall. Pro se indigent defendant, inmate.
Yeah. Yeah. I know, right?
Oh, you gotta love her writing.
But she's kind of covered it all off. And I know it's a long letter, but she's covered it all off. She's made sure she's gotten it all because she knows that this is not going to get there for a couple of
No.
days. What date
And
was it?
she-
Does it have a date on
Fifth or
it?
sixth?
5th or 6th, and today is like the 10th your
10th.
time, and it was there
Published yesterday. Or
Published
7th, it was
yesterday.
dated. It was filed
Yeah.
on the 9th, so 2 days. And that's kind of fast
Okay.
from what's been happening.
It's a little bit quicker than it has been,
Yeah.
probably.
By a day or so.
Okay, but still, it takes days because she can't email it, which is ridiculous. Okay. So good on you, Sarah. This is for Wednesday court.
Yeah.
Okay, because yeah, we have another one on Wednesday. Things are happening.
Yeah, the 14th at 1:30 Eastern.
That's the one we can't see, right? That's the closed one. Pretty sure.
It's just a status hearing.
Oh, it's just okay.
So maybe I'll have to dig into that.
It's the evidentiary one that we can't hear. It's the one where they're
Yeah.
going through all the evidence.
I don't know when that is.
And
though.
that's fair. That's fair. She's like, I don't think it should be televised. That I'm like going through all the evidence and stuff like that.
Okay.
And
Wonderful.
and he said, sure. Captain will be at Wednesday hearing. It's open to it. Okay, sweet. You know stuff, don't you? Beautiful,
Yeah.
waterfall. It's so good to have you here. Thank you very much. Appreciate it. Okay, let's keep going.
Digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to
Hey,
that
Scott.
first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane.
I always think of Chicken Cacciatore when I hear of him.
The exhibit list with our expected items of evidence that we received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions, and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question.
And I
Okay.
have a copy for defense.
Okay, very good. Deputy Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses in trial. I don't have an order or.
It wouldn't be an order, it would just be that first document, right? Reference to notice of provision of witness list.
Got it. Okay, thank you. All right.
Yeah.
Anything else with regard to the expected evidence and
Christ's sake.
digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone.
Yes, they're broken down by folders.
Oh,
And the
look.
folders are the names of
I
the
wonder
folders
how
that
he
match
charged his
the
laptop up.
names in the digital evidence list.
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone.
Thank you,
As
Flashman.
opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to either send it to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copies retained.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Cacciatore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, yeah.
Okay, ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay, do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean
Okay,
not open
have
a
a listen to
file?
this and then we'll
What can you
chat
not
about
open?
it for a sec.
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats, but there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay,
So I don't
what does
know.
it say?
I don't know. I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. That's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Pause.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files,
Pause.
20
Forever.
files, 50 files, or is it just a one time and then you moved on to something else?
I don't know how many files were in it because
That sounds to me like a zip file or probably a RAR, RAR file. RAR.
Yeah, yeah.
That's a similar to a zip file. It's a somewhat compressed file with numerous other files inside it. Exactly.
Yeah.
Okay, Brad. Thank you. Yes, some files are probably zip and other files are probably RAR. So
Very similar.
it's a blank laptop that probably doesn't have programs set up to open certain files. Even my normal computer had issues when I've gotten files before from courts and police stations. I know what I'm doing. I don't know how literate Sarah is with computers, but regardless, it's a very limited laptop. She has very limited resources to open stuff.
Can I just say something also? AG, hey AG, how's it going? Look, even if she is a boomer, or regardless if she's not a boomer, it doesn't make any difference. She can't download any software.
Yes.
So
And
it's say this computer has no Windows file extractor, right? So say it's got no WinZip, it's got no rare unarchiver, it's got nothing to actually open these files. She can't download anything to fix it. So even if she's quite computer literate and knows that she could double click or right click to go and onto the internet and download some software to fix this issue, she can't. So
Yeah.
and the judge is like, well, he's no IT consultant. That's not his job. And this is what's going to happen. It's going to go round and round in circles. It's not the judge's job. It's not the prosecution's job. What are they going to do? Hire somebody to come and help her? They've spent enough government money, haven't they? So they gave her a laptop. She's a boomer. There's no internet. She's filed a motion. Well, that wasn't even a motion. That was just a letter that we just read out for internet access. Actually, there was a motion for internet access, wasn't it? That was last week.
well, it was mentioned in here as well.
It was mentioned here as well. Okay, she's come close enough now to proposing that she has internet access. That's enough for a pro se defendant, surely. They're not going to give it to her as if she's going to get internet access. She should. That's an appellate issue. That one there has to be an appellate issue. She has to have that to prepare for
In
trial,
theory,
surely.
she has access to like a law library at the jail. I agree that's very limited, but she has research materials.
Her investigator can open them for her, though. But is he allowed to just come to the jail and sit there and open them for her, or does she have to identify all of the files that she doesn't know how to open, make a list of them, send a letter to her investigator, have the investigator open the files, put them on a zip disk, a zip drive, have them then have that
USB.
then transported back, or USB, have that then
You have to, like,
transported
convert
back to
them.
the jail. Yep. And then she gets them, then she tries to open them, then she doesn't have the software. I can see this happening. This is going to be an absolute shit show She's not going to have access to these files. She's
Mhm.
not going to be able to work on them. And no one's going to care.
No.
No one's going to care. The investigator who made the files was going to show her
Yeah.
the next day. Yeah, Billy Lang. Well, I think that Billy, did she meet with him this morning? I wonder if he was able to sit with her with the actual laptop. I wonder. Let's hope the investigator's tech savvy. Well, you would think that he would be able to just open some zip files. But question is, when he's sitting there with her, assuming he's sitting there with her with the laptop, that they have internet access because they're in the jail. You would wonder.
Yeah. And it's
I think both of these cases will happen. Yeah. I see why you care about her, but is she actually not a killer? That's not the point, Dr. Hines. It's not the point. She is innocent in the eyes of the law. She deserves a fair trial. It doesn't matter.
and
Does not matter.
frankly, I think the biggest issue right now is it second degree or is it manslaughter?
Mm.
And there's a
Yeah,
big difference.
if we
in
want
that.
to talk what the charges are, sure.
And I could
Huge
see
difference.
with the facts I know, I think she is guilty of something. She gets a fair trial and a fair defense in theory. But yeah, is it manslaughter or is it second degree? There's a huge difference there. And there's a case, in my opinion, for manslaughter.
Yeah. One of them is she doesn't have a life. One of them is she does have a
Yeah.
life to live. And remember, she's got a little son.
True.
Right? Everyone forgets about her son. She had a little son. He would be 12 now. And he's without his mum. Everyone forgets about the victims on the defendant's side. So, yeah, she got a little boy. You don't know the case? All I know is suitcase and husband is chopped up.
No.
What? No.
No. He went into a
No.
suitcase. They were playing hide and seek, she says. And then there's a video of her yelling at him because she was abused, she claims.
Yeah.
She was drunk. She went to bed, woke up. Oh my God, George is in the suitcase still, and he was no longer alive.
Yeah. Sarah, I can't breathe, Sarah. Yeah, no chopping uppy. No choppy uppy.
No, she's not like cruel or anything.
She's not crazy.
Yeah, she's not weird.
She's not weird.
Didn't bother.
I think you are, Hines.
I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what for the most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
All right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC.
Because it's all standard, so therefore they've done their job.
All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
100%, Brad.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State, anything else we need to talk about? with regard to that issue?
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning.
Yeah.
And you advise the court
Right,
that you are
beautiful
going to be
work,
meeting with Ms. Boone tomorrow.
Thanks
Is
for
that
your
correct?
input. It's good to have you
About
here.
approximately what time are you going to be meeting with her? If you know?
I am.
Okay, all right. I have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of
No.
the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Ms. Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those. and
She's
have
going to
them.
get paper
So tomorrow,
copies.
when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously, and Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this, State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No, Your Honor.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28th, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You had the smaller one, which was everything you digitized from the 2 boxes, and then you had the larger one of other materials that you've been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has the physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right, ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay, can Mr. Lane be released?
Yes.
Okay, if you want to, can he be released, ma'am?
I guess I'll see you at 9.
Okay, sir, if you could endeavor to do that today, I would greatly appreciate it.
Absolutely.
All right, thank you very much, sir.
Thank you.
All right, the next matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed in the court on August 5, 2024. Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Unshackle her.
In speaking with courtroom security, we would oppose the motion.
Free at
We
last.
have a
Free
full
at last.
motion available to
God almighty,
supplement
free at
the
last.
court's knowledge.
Okay.
Dialogue through paper and
State
sister.
will call the call. He will be
Collect, call, CompuServe.
and you'll be given the opportunity to ask him questions or cross-examine him after
Hey,
the state's
Amy.
concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness. State.
State recall Gavin.
Okay, here we go. The little scared man.
Aw.
He's scared of the 45-year-old woman
He's
who
kind of
runs
small.
around with luggage.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LWTA.
All right, thank you.
Watch out, she might get you with a handbag.
Good morning, sir.
I got some luggage with your name on it, sir.
I work for the Orange County Sheriff's
Hey,
Office.
she's sizing him up. What size Samsonite could we
And
fit him
what area
into?
of the sheriff's office are you assigned?
He's a bit pudgier than George.
And how long
Hey,
have
I've
you
got
been
one for Kurt. I got one for you.
Over 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies.
No.
Oh, that's sad.
She will too.
And
Yeah.
are you familiar with the defendant in this particular case?
Just through research.
How depressing.
I don't have any personal knowledge from it.
And what, in regards to that
Junior.
research into the defendant?
She should tell everyone it's her birthday.
Position,
Remind the jury.
Yeah.
Her request to be free from shackles.
I do not.
Oh, Dali, do you have incident reports?
And why is it that you have come to that conclusion?
Based
Oh,
on
yeah.
her current
Yeah.
charge of second degree murder,
1 sec.
she also has previous domestic arrest.
Forgot about
for
that.
battery by strangulation. She has 3 separate incidents at the jail for non-compliance.
Hey,
where she was
Combs.
told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings.
This is goddamn ridiculous, this argument.
Combine all that, to me, it shows propensity for violence and not wanting to follow.
Propensity for violence?
Of law enforcement personnel.
What?
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained?
Oh, look at his face. I want to.
When the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise. To alert the
Oh,
jury.
she'll look like an Australian breakdancing in the Olympics.
She would
Shut
be
up.
in and sat at
Touched a nerve.
defense table prior to the jury coming in and being seated, so they wouldn't see her walking in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions.
Okay.
Thank you. Ma'am, do you have any questions for Officer Loden?
Let me know.
Yes. Why are you scared of me?
First off.
Let me know, do you want me to
for
whip it
in-depth
out?
Research that you've done on me, the
Yeah, whip it out now.
domestic violence.
Pause it.
Okay.
strangulation was dropped.
Right. So, guys, check this out. Funnily enough, because Dali did a records request, and there's still more things we hope to get from the records
Yes.
request. Hopefully, some jail calls, because that's what we really want. But what Dali did get happens to be what they're talking about now, and that is
Ironic.
this. Ironic, yes, that's this. Do you want to zoom
It's-
up?
Excuse me while I whip it out.
Yes. So these are those incident reports, right? So about when she didn't want to go to court. And
Yes.
I thought it was interesting because when Dali sent these to me, he said there's nothing really spicy in there.
Yeah.
And I went, I find it spicy that there's nothing spicy. Like
Mm.
in 4 years of her being in this jail
Yeah.
setting with all these hundreds of women, and the only thing they've got on her is that she didn't feel like going to court a couple times. That's it. Like she didn't get into any altercations. She didn't piss anybody off. Not intentional. She
No.
didn't piss anybody off. Nothing's happened. And if she's really this disagreeable, if she's this much of a bitch, this much of a troublemaker, you'd think that she'd have like some things on her record over the last 4 years. But no, this is all we've got. And then this comes up in the hearing yesterday. So, Dali, just want to explain.
And just first of all, half Irish, I personally think she wasn't awake when they told her to get up for court.
Yeah, that too. Yeah, it's 3 a.m. What
It
do you
was at-
expect?
Or midnight at one time. But anyway, so yeah. Okay. Ooh, a strip search completed. Yikes. So I think the first one is at the bottom, so I'll start there.
No badge of witness. I don't think so. Whether
So-
the dates her attorneys appeared and then she wrote letters mad because she wasn't there. No. No. This is a long time ago.
Yeah, this is 2020, February 26th. Inmate placed on pending protective custody status due to being featured on local news outlets. No force used in this incident. Sergeant Johnson was notified. Oh, I hope he doesn't get promoted to major.
Okay, so hang on. This is not her fault. This was her being put in the hole, right?
Yeah, and you didn't get that joke.
Uh-huh.
Sergeant Johnson promoted to major.
Okay. Anyway, you and your ping jokes. Anything, any opportunity with you.
I know.
You're like 5. Anyway, this was her being put in the hole for her own protection.
Yeah,
correct?
because she was featured in the news.
Because she was featured in the news. All right. So this is nothing.
Yeah. So then 23 months later, I, Officer Scribner, was assigned to a dorm at the female detention center on January 28th, 2021, year of our Lord. Well, first of all, it also says date 2022, January 28th. So can you get the date right, sir? You see what I mean?
Huh? What?
Okay, the date of the report is right here. 1/28/2022, year of our Lord.
Yeah.
In the circumstances of incident on January 28th, 2021.
Oh, I got it wrong.
Lord. Yeah. So I don't know which date it is, but the dummy got it wrong.
Okay.
At approximately 3:34 a.m. hours, inmate Boone, Sarah number 200005623, was advised she has downtown court and to start getting ready. Inmate Boone stated that she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. She asked me for 5 more minutes. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. Inmate Boone stated again she would not be attending court. Booking and Release transport officers were notified of her refusal. No response to resistance was used in this incident. Information notes were entered into her inmate notebook. But Sarah had absolutely no memory of this, and I believe her kind of confusion and outrage at it.
Okay. Which we'll witness in a minute. Well, she's not. I don't know if she's outraged, but
well, she was kind of surprised.
Like I don't remember it.
Yeah.
Yeah.
September 15th, 2023, at. Well, now this report time says 2:59 a.m., but this is at approximately midnight. I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated that she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone said that she understood and continued in her decision to refuse. How violent of her.
Very violent. So scary. I'd be scared if I was a guard.
So then 1 month later, on 10/16/2023, Officer Christy Green, at approximately 300 hours, I advised inmate Boone that she was on the schedule to attend downtown court. Inmate Boone stated that she did not want to attend court. She needs her beauty sleep. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. She understood and it continued with her decision to refuse to attend court. Rude. And that's it.
That's it. That's it.
That's all this woman, who is supposedly the patron saint of Karens, has been guilty of.
Guilty of in 4 years, locked up in this absolutely intolerable environment. I couldn't handle it. I would lash out in the 4 years there. I would have moments when I would lash out for sure.
And honestly, that was my exact thought. I think she just rolled over and went back to sleep.
Yeah,
She was told she needs to get up at 3 a.m. I don't want to. I'm tired.
Yeah.
Just leave me
She probably was
alone.
asleep and annoyed at being woken up. I mean, I would be too. It's really hard to get sleep in those places, apparently.
That too. And
Yeah.
she complained in the last hearing that a guard woke her up at 3 a.m. And told her she had to get ready for court. And she had no idea court was that day.
She didn't know that court was happening. Yeah.
And now she has to go because she's representing herself.
Yeah, they're making it sound like Brooks. They are.
Yeah,
They're making it sound like Brooks. Brooks is a violent criminal.
Yeah. Or Bradley Young in jail.
Yeah.
They cheered when he went to prison. Not because he went to prison, because he was out of their facility. He was that bad.
Yeah. Yeah. This is the thing. It's just like people are so hung up on this idea that she is just this intolerable person. And I don't see it.
She isn't easy to get along with, but
No.
she's still conducting herself with a little passive aggressiveness. But for the most part, I mean, and in her situation,
she's in a shit situation.
Yeah, I don't blame her.
Yeah, I mean, you get me in a situation like that, and I'm gonna probably not be my best.
Trust me, just get her backstage first thing in the morning. Oof. No, I'm kidding.
Oh, fuck you. Okay, let's keep going.
I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what?
Hey, Brittany.
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor?
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Just give her some latitude, dude.
I don't know, like, I feel like she's probably going to learn from this. I feel like the asking compound questions, she can't just keep getting away with it. She needs to learn.
Attend October 16th, 2023, and January 28th, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At
court?
the jail, yes.
Who is your contact, please? I've never missed a date.
This is a database that I got this information from.
Do you know when it was last updated?
It's, I don't know.
Okay, so do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going. Do you know the name of the officers for each one? You do? Please.
For September 15th, 2023, it is Corrections Officer Portia Hines.
Can you pause real quick?
Hines.
And that is the document we have, September 15th, 2023. And then they're just going to be describing the notes that are in this document here.
Okay.
So I
That's
just
the
wanted
one
to,
with Portia.
yeah.
Right. Portia.
And you said the date was 9/15/23?
Correct.
Okay,
And if you would like, I can read her comments in her report.
sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is.
Okay,
What has this got to do with her being shackled?
It'll be Officer Christy Green.
and what is this date for?
If she's violent.
That's going to be October
Exactly.
16th,
It doesn't prove that she's
Okay,
violent.
Sorry, the name?
Green, G-R-E-E-N-E.
Doesn't respect authority.
Okay,
Authority.
G-R-E-E-N-E,
yes,
10/16/23,
yes.
okay?
And the third one is January 28th, 2021. And the officer is Jasmine Scribner.
All it proves is don't wake her up at 3 a.m. You'll be
Yeah.
fine.
Comments, please, for-
Okay, don't have court at 3 a.m. You'll be fine.
Approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did
I
not.
believe this is all they've got.
Informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward at the Booking and Release Center.
It's really easy to get written up in jail as well.
All
So
proper notations were made in the IMS.
Okay. And January 28th,
Approximately 03:34 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
Right, Schnibbles?
and all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program.
It might, but I didn't take that information down.
Okay, so I'm trying to figure out how I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to ask and answer.
I'm going to sustain the objection.
no, that is a good point you made,
So the
Hella,
domestic
that
violence, the
it's
original
good she
was
gets to
dropped.
learn
I was never charged with that.
how this
Yeah,
works.
yeah, this is a small hearing. It's not the end of the world for her to get some
There's
objections.
no jury.
It was dropped.
There's no jury.
That's all that matters.
I don't know why.
She'll
the state
learn.
dropped it. It could be because both parties.
He,
based on the report that I
he
read,
did ask and
not
he did
want to
ask and he
cooperate,
did
so they
answer.
probably didn't have information to go
She
forward,
needs to learn that.
with the charges. That does not mean that you didn't commit the act, it just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
Your
It's
Honor,
a-
Your Honor, I'm going to object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way apparently, so I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
That's getting old.
I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that is your history.
I understand, but I was never charged with it, correct?
You were charged with it.
It's irrelevant then.
But it is not on my record.
The rest is on your record.
But the charge.
The arrest
for
is on the
the
record.
domestic violence
So
is
what?
not on my record.
No,
I'm
you were
going to
never
object this
convicted.
to ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you.
No.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it
Your
a,
Honor, I'm going to object to the form of the question. This is a statement, question.
Yeah, Brittany, I'm sure, I don't know if you've seen the body cams video that's getting around. And it's also, there's a list of incident reports. They never press charges against one another. With the body cams one, there's a video that we did the other day, and one of the incident reports said that the officer actually wrote that he couldn't determine who was the main aggressor. She said that he kicked her in the eye and she had a mark on her eye. She was the one who called 911. I think in both instances, I think she called 911. But then again, he also stated that she was chasing him around and wanted to hurt him. He was taken to the police station on one of these occasions. I'm sure she was too. So yeah, they were it was very toxic situation that was going on. So yeah, it's tough because I mean he's deceased, and you don't want to speak ill of the deceased, but they definitely. I mean, you don't want to say okay. You don't want to say definitely because neither of them were found guilty of anything because they didn't charge one another. But there were incident reports, there were complaints, so yeah, and there were bruises and things like that. So what can you say about these things? It's just very sad situation. Oh, you never know, Bob. It could still happen.
For the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's
Lame
legal
question.
basis for you asking that question is correct, and the court will not permit
People
you to
have
ask
gone
that question.
berserk about this,
In the
about
way
her
that
going,
we
what
asked.
sustained mean?
What do I need to provide
like-
to you in order to have that remedied in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
It's like the one funny thing she said the entire
Whatever
time.
documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made,
What's that?
the decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to asking as a
Sustained.
So frustrating.
Do I provide this information to you?
You can provide it to the state.
Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've
Bad question.
researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
And
Very
then
bad.
What was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024.
Yeah, I cringed when I heard that the first time. I'm like,
Okay.
oh.
Yeah. Don't ask a question you're not going to like the answer to, Sarah.
What, the arrest affidavit?
And you know he's
That
gonna
you're
not.
using
He's
to
not going to give you a good
conclude
answer.
Due to
No.
this occurrence that was dropped, that I would not be able to be unrestrained.
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
Leave it alone, Sarah.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
If you have any other questions.
Do I need to supply anything for the?
Don't be so
2018
polite,
domestic
Sarah.
violence
You're a lawyer.
occurrence
You can
that
be an
you were
asshole. It's
referencing
okay.
online?
Well, yes and no.
Dropped, I'm just telling you.
Yeah, I
She
suppose
needs-
in
she
her
needs to
case.
say
Even
face.
though it's not.
Yeah.
Yeah.
Right.
In her case.
Okay. Thank you for the information.
Well, she's not just the lawyer, she's the defendant. She can't be an
Yeah.
No,
asshole.
Your Honor, it's fine.
Thank you, sir. Anything else, Dave?
Nothing to say.
Okay. I see Deputy Barnett here. Did you come up, sir?
See, here's the thing, right? I find it absolutely disgusting that the state is even opposing this motion. They shouldn't be opposing this motion. This is stupid. Like, she's clearly not a danger. It's so obvious she's not a danger. Yet they're just opposing it to be assholes.
Yeah.
Like, she's her own lawyer now
And-
against her will. She has to figure out a way to put her case forward in freaking less than 2 months. And yet here they are opposing her being able to just move her hands around and take notes.
And you'll notice, like, we've seen pro se defendants normally, like Brooks, and the state was really good at not being assholes to him unnecessarily. Even like Franklin Tucker, the treehouse guy, the state became assholes when Ty proved that he was a threat to them, and they had to kind of step it up. But there's no, like, Sarah is not a threat right now. There's nothing to be gained. You're just being assholes for no reason. It does not look good. I don't know if Brooks,
look, I mean,
I don't think
having
he
a
did.
shortcut. No, he did.
No,
He did,
the judge,
on his legs.
he said he did. The judge then clarified later that he did not.
Oh, okay.
She wanted that on the record.
Yeah, why are they fighting her on this? It's stupid. It's stupid. It's just, and no one cares, guys. We're the only ones who care. Like this chat and Sean's chat a bit.
Yeah.
We're the only ones who care, right? Everybody else on the entire internet is like, yeah, keep her shackled. Yeah, she deserves it. She's put herself here. It's all her fault, right? And people are saying things like, oh, well, I bet George wanted freedom of movement. That's not the point, right? You guys have already judged her and decided, you know, throw her down the river, like put her in a cell and lock her up, throw away the key, all that kind of thing. She deserves her right to a fair trial. And at the moment, she's her own lawyer and she can't even write a goddamn note without taking skin off her arms. It's shit. And she's asking very politely and kindly. Like, she's not acting up. She's never lunged at any prison officer or anything like that. It's stupid. She's that person, though. You give her an inch and she'll take a mile. But that's the other thing, though, Brittany. People are just making assumptions that she's going to do something. Do you really think she's going to, like, lash out at somebody in the courtroom? I can't imagine that. I just can't fathom that idea. I've never seen her do anything remotely physical
And it seems like
in
all
any of these
her
situations.
domestic violence involves alcohol.
Yeah, yeah. So, yeah, people are just all like, oh, well, she did this, so therefore she's going to do that. And this seems like a big reach that she's going to be, like, physically violent in the courtroom. Yep. Okay. And yes, there are enough court officers around her to apprehend her if she gets out of hand. Yeah, I mean, she's a 40-something-year-old woman. And there's all these men around everywhere that are armed. Come on. Come on. This is just, yeah, it's silly.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Oh, look at this dude.
Oh, boy.
I'm sure, like, she's got a giant luggage.
Captain Male Pattern Baldness is here to save the day.
Deputy Sheriff's at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge.
I supervise squads under the bridge.
Training that's addressed with regard to other security measures other than shackles.
I make sure
that may
people
be
don't
provided
cross the
for
bridge.
defendants.
Yes, we have an item called stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's a box secured to the leg.
It's used in my BDSM fantasies.
Bolts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the hands and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will,
I don't think she's asking to get close to witnesses, though. She just wants enough freedom of movement to make notes and things.
No, she can use the bailiff to hand stuff to the witness. Same with state.
Violence, type of escape, any actions that lead to that level of to use the device. It's a two-step process, so there is no way for it to accidentally be set off. It has to be hit two separate buttons or accidents. If it had been used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could take care of the situation.
Are there any other protocols or standard operating procedures regarding the use of the sub belt, other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, is at a level 3.
And what is a level 3?
3 would be failure to follow directions and stuff like that. If we have to get up and move or not, or follow off order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. We take it off as court every time we exit the court. It takes a few moments to sign the waiver and security to the waiver.
And it's a one-time waiver?
Each day you have to resign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes,
and remove?
yes.
Thank you.
Any follow-up?
Nothing to say. All right.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. Stun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stun cuff free, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
Thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
She needs to stop saying supposed.
Because that would be me providing you legal advice as to what you could, can, or should.
She needs more confidence, which I get she doesn't have,
Would
but
I be able to be unrestrained with that information?
I think that would come.
It just
down
sounds
to
passe.
the argument of yourself and from the state as to what the court has to consider with regard to your request and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification. Because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cashstory has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just
Very
for
passe
the majority
here.
of my motions and letters and so on that I have supplied the court for more information to try to intervene and help. It's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. But you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I review your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom.
I love how they zoom in on them.
You wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify
Over and over and over again.
this time, you can as to what it is that you're asking of.
Yes, handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
Free at last, free at
I know at
last.
some point I would have to maneuver.
God Almighty,
in the
free at
courtroom for
last.
trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know.
Oh,
So I
Jesus,
was just
Brittany.
trying to be transparent prior, so you would know what it was that I was hopefully expecting. The first
Go ahead.
is just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay. Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial, yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now, just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she's an inmate. Does that mean the state will be sitting at a counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed. to be able
What?
to progressively and actively participate.
What are you, my
comprehending
ex?
The same as others with just simply being able to write
Oh,
notes.
stop going on about your ex.
At some point, I'm sure
I never
will be
said which
bringing
one.
things with me to court that I need to reach
I thought there was
for
only
to
one.
then to pass normal functions in a body as a whole.
No,
with
there's
same
the
equal
bisexual
anyone in the courtroom would
softball
have in
player.
order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy already identified, Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed, just to simply take notes and function normally and equally, just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, you're just address all the concerns, which is the court's line.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder was representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when you get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who was in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so now the court's gonna grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs.
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right. The other
Ghost.
item I have.
Stop zooming in on our feet, for Christ's sake.
Hey, what's with that?
I think the situation is.
Good Lord.
She has handcuffs on now. She doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs will be restrained.
Okay, I'm getting a thumbs up from the deputy in the back.
Our TV has a thing for only feet.
Deputy Logan. Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes,
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. We can take those off.
In
You
advance.
guys up here.
Yeah, I understand
The
that.
judge overruled the jury.
Especially when we bring in.
To give her death. Wow.
Okay, and for the purposes of trial,
A prick.
you'll have no leg restraints.
Glad that
no
was
hand
overturned.
restraints. Your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're gonna have to sign that waiver every day, okay?
To your
Let's
ankle.
everyone send her some pretty
The
socks.
stun cuff, does it go over clothing or does it have?
It is under your clothing as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's gonna have a conversation with you, ma'am, after our hearing, so she can facilitate.
Oh, you're asking the public defender's office to meet with her now?
That would prohibit the jury from viewing that device on your legs,
Yes,
okay?
thank you.
All right.
For her wardrobe.
Does that clarify for you, State?
Yes, I just saw them and I thought that, I saw the confusion based on my experience of how it's done.
Okay.
Penguins.
Thank you. Now, ma'am, that doesn't mean that you're gonna be able to wander wherever you want in the courtroom. There's gonna be.
You
spots
can't wander
you're gonna
wherever
be
you
able to go to.
want.
You're not gonna be able to walk all the way up to witnesses. You're not gonna be able to walk everywhere that you want. There's gonna be places that you're gonna have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm gonna give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was gonna, either you can do it or I was gonna have the deputies do it. So, ma'am, I envision that because you're gonna be able to move about freely and our jurors are not gonna know that you have any restraints on you, and they're not gonna be able to see the stun cuff.
Yeah.
You can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm gonna ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand, and you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I've spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal, basically closer to you. So that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that's
Well,
my
okay.
preference, please. Thank you.
That's
So-
what I'm endeavoring to try to do for you.
Yes.
All right. So they're happy to pay for an extra deputy to be next to her to just basically courier things backwards and forwards so that she can't move. But she can't have standby counsel. Because she might use standby counsel as a lawyer. Because you know what? She doesn't know how to deal with lawyers. You can't trust her. Because she did something, she was apparently rude to some lawyers, and therefore she can't be trusted to deal with a lawyer who's a standby counsel. Well, a lawyer who's standby counsel has a completely different job to do and has every right to tell her, no, Ms. Boone, I can't do this for you. I can only do these other tasks for you. I can write up your motions and I can answer some legal questions for you, but no, I can't actually present your case. I can't get up and speak for you. I can't actually come up with your strategy for you. That's up to you. She's never had standby counsel before. So the judge was not willing to give her standby counsel. The state's position was that the judge had already ruled The JAC wouldn't put forth any funds towards it. However, the judge is happy to just give extra staff to have a guard walking around and handing things backwards and forwards. Grr. Grr.
Okay. Any other questions about the ruling?
Yes, sir.
Okay, so your motion is granted for the reasons stated on the record.
She was
Stated-
rude to the other lawyers.
All right, the last issue that I had on my list this morning was
So
the scheduling
rude.
order and notice of hearings that the court entered on August 5 required the jail to provide.
They're a bunch of pussies.
Every
Sorry
Monday at 9 a.m.
for my language.
August 12, 2024, a representative from the Orange County Jail sent email to my judicial assistant, email provided in the order, all notebook entries from IMS.
Surely
from the
they've
prior
dealt with
week, Monday
worse
through
than
Sunday, for
her.
every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today.
Well, give her a chance though, Brittany. She's never had standby counsel
Is there
before.
anything else, state, that we need to address?
We would think the judge would bend over backwards to
Ma'am,
make
is there
sure
anything
she
else
had
that you'd like
access
to bring
to
to my
anything
attention?
she could
Yes,
to
please.
represent herself.
Yes, ma'am.
In regards to the status report, you were just speaking about regarding them providing me with a laptop each day.
Yeah, it's a totally different
What
thing.
is your
I
definition
know.
of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, my concern was they're not stating what it was that I looked at for how long and
I don't know that
anything.
they're going to record that information on the protocol, ma'am. It's
Okay.
just simply what is checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. in courtroom 12A, Orange County Courthouse, and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
The
here
media,
in the
yes,
courtroom?
ma'am. I pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required.
That's interesting,
I know that
Brittany.
we
I
have
thought
a
that
hearing that we had set
when Ty had
for
a standby
August
counsel,
14th,
the standby
which was
counsel was
to
doing
address,
his motion,
a
writing his
couple other
motions.
issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30.
Correcting them at
Jail has
least.
confirmed that they have space, and Mr. Lane's taking care of that today. But I do
Using
want to utilize that
legalese.
hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problems with my Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media.
No, Brittany, that's not what I meant. So no, I didn't think that they could make any arguments. When I say write motions, I don't mean write motions as in make up their own motions. I mean like help interpret whatever it is that the lead counsel, as in the pro se counsel, is saying, and type, make, so say for example, Sarah Boone writes her motion in handwriting like she is currently, and it's just not in legalese. the standby counsel can correct that and help her to submit it to the court. So I guess that's paralegal work, but paralegal work when like they would start the document from scratch and finish the document and then submit it to the lawyer, and the lawyer would go, that's not exactly what I wanted to say, and fix it all up. Whereas no, I'm just saying that she still would be the one writing the motion. The standby counsel would just be helping her make it into a legally sound document. So not sure if we're on the same page there. Definitely not write or make arguments or anything like that, because yeah, she's still in charge. And but the difference here, and what I was trying to make the point is that that lawyer would then have every right to just be like, no, I don't do that. I don't do that. I don't do that. And that'd be it. Quite simple where they could draw the line. And what is with these lawyers who just can't stand up to people? The thing about it is, and it's what Mentor Lawyer was saying, because he went and visited her, and he came back and he made his video about it, which is all very controversial, is that like these public defenders, they usually in private practice as well, and they have a big caseload, and then they unfortunately are human, and they're supposed to treat everybody equally no matter how much they're getting paid. But if they have these private clients who are paying this much money, and you've got the public defender clients who are paying this much money because it's a set rate from the state, and if a public defender client is a bit annoying and taking up a bit of your time, and you can accuse yourself, why wouldn't you? When you want to give more of your time to your high-paying clients. So, and you've seen 2 or 3 others already just be able to walk into the court and recuse themselves that simply. Why wouldn't you just walk in and go, irreconcilable differences, see ya, bye. And the court's been really easy with it. They've just gone, okay, see ya. Yeah, I know, she's annoying. Okay, bye. Like that. So everyone's just been eating this up. They've not made it difficult at all for these lawyers to walk. So their patience doesn't have to be very much. Like they don't have to have very thick skin. They just walk away and they go back to their private clients. I don't know. I'm a little bit skeptical about this whole thing. A lot. Anyway, moving on.
Concerns.
Yes,
And that will be heard on August 14th at 1:30.
Bless you.
Status on the digital. Now, ma'am,
Thank you,
based on
my
the
son.
scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane.
Oh, no, ma'am, the USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections.
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This letter that I supplied to Captain Di Giovanni upon her return, knowing what I'm requesting. I don't know.
Oh, please no.
To tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives and just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
I can't wait to find out how that went.
We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain DiGiovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on media request or prevent media from being at the September 3rd discovery viewing hearing will address your concerns as identified in this letter and have a representative from the jail, be it Captain DiGiovanni or someone else here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
But you're talking about the September 3rd evidence unit, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
Okay.
No.
So
Okay. I will see you.
Sean commented on this yesterday.
30. Oh, thank you.
Okay, so the fact they even need to discuss whether or not the media should be there for that evidence viewing is really quite strange, considering that if it were an actual defense attorney or any attorney viewing evidence in a room, there's no way that media would be there for that. So why should media be there because she's viewing it? That would absolutely be a confidential viewing. So, yeah, very strange, very strange. Not really sure why that's even up for discussion. That should be a closed viewing. And for those of you who didn't see what he said about that, I'm obviously never seen one because apparently, yeah, these are usually things that the prosecution and the defense go and do privately. This is where they get together, or they might do it at different times separately. And it would have happened ages ago. It's just that she's just been made the lawyer for herself. All of the discovery, and I mean exhibits, get put out on a table. If there's a gun involved, in this case, there's a suitcase involved, there's pictures, like there might be autopsy photos and things like that. They're put out there and there's an opportunity to physically view them. So she might get to actually touch, but with gloves, the suitcase and make sure that it's the one that she remembers, that it hasn't been changed out with some different suitcase. She gets to look at the autopsy photo. She gets to look at all the other exhibits. So everything that will be presented at trial, she gets to see it and touch it if she wants to physically. And so she's arguing that there shouldn't be any media present for that. Duh. Yeah. I don't want to see the evidence before the trial anyway. He had to cite case law and make the ruling. Yeah, he'll block the media. Of course he'll block the media. But yeah, why is this even a thing? Yeah. I'm noticing, okay. I need to learn the brand and model of the suitcase. I know. I do need to know this too. However, I suppose we can wait till trial. Okay. Oh, was this? I downloaded that 150-page monster document too. It's not as interesting as I'd hoped it would be. Okay, so when we're talking about the 150-page document, we're talking about the, so
Yeah.
You decided to go pro se.
I just got it. I'll send it to you. It's not We can
I'm sure
discuss
it's
it
not
for next time.
exactly very interesting, but
It's not a page
just-
turner.
I just thought it would. I just thought it would be kind of hilarious. Maybe I'll redesign it.
Oh, yeah. Suitcase still has a "We Search Your Bag" TSA flyer in it, or a little note card from the TSA. Get your freak on, girl, when they discover a vibrator in it.
I want
That happened once.
Hey, who sent us a warning tag from the luggage company? Do not get inside. There should be a warning tag. Hey, Chinny, your little Aussie blogger's here. How's it going? And Mavka, good to see you here too. Okay, so we'll just finish this off. One more thing I want to show you after this very briefly.
The attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you.
The pro se packet.
Mr. also send you a copy by way of mail. It was already mailed. Okay,
Jeez,
we're
it's
gonna mail you a copy as
123
well now.
megabytes.
Today, I'm gonna give this to the deputy, provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said would be meeting me downstairs?
They're gonna be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
Miss Click.
No, Your Honor. Any other questions, ma'am?
No, Your Honor.
All right, we'll see you August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail. Thank you.
Okay, so hang on. Where is it? I recall her boyfriend wanting some freedom to move about. Now, hang on. She is trying to gaslight the judge as if she is pro se because no one asked her questions. She's insane. I love how she implies it's the court's fault that she is without counsel. Oh, look, who cares? Let's get on with that. The woman has a black belt in Karen. Oh, now she's going to try and drag every single portion of this out, every step of the way. She talks about not wanting the media around. What?
Bud is basking in the glow of the pubic's attention. 87 likes.
There's something else here that interests me. Where is it? Oh, hang on. Where's the thing about someone went off about mental lawyer here. Hang on, let's search. Oh, here we go. Here we go. Can you read this one?
How kind and like generous of YouTube's mental lawyer.
You have to do this voice.
To go visit Sarah Boone in jail. Grody. So that, like, he could give her some solid advice and Swedish fish to help her overcome the bullies in the court system. The video was entitled, "I visited Sarah Boone in jail. She needs and deserves a lawyer." But Grody, he quickly deleted it, like totally. Likely because he doesn't get too much criticism. More criticism. He claims to have visited her 3 times recently. More visits, more. I have to wonder why he didn't utilize his spare time to go and offer condolences to Jorge's family.
Well, there you go. There you go. 111 replies to that. Wait, did this really happen?
Like, wait, what? Did this really, like, happen? Grody.
People do anything for clout.
Like, he used to be a criminal defense attorney. Oh, sorry, that was the comment. Sorry, beautiful waterfall. I wasn't making fun of you.
No, man. He used to be a criminal defense attorney and a prosecutor. He was both. This dude did both. Yes. Yeah. Yes,
I have a hard time like separating my voices and chat.
Yeah. Sometimes he makes fun of people in chat because
And I don't
he's
mean
just
to. Like, I
a
love you
retard.
guys. I'm not trying to make fun of you. It just,
Ah. Yes, it really happened. I saw the video a few days ago, shortly after he posted it. It wasn't up very long before he deleted it. So I guess I wasn't the only one who slammed
he
his
did delete it.
desperation for views. No,
That
he
wasn't what he
didn't.
was.
He's got 2 channels,
Oh, does
and
he?
he deleted it from one of them, his professional one,
Okay.
apparently. Hang
And
on.
he was like really like trying to help Boone and not make a circus of it. And
He was trying. He wasn't even. I don't think it was so much helping her. It was he was interested
yeah.
in her side, and he was just curious. I think he wanted to see whether or not she was as bad as people were saying, and he was
Fair.
interested in her rights. Just like we are, just interested in her rights. And he didn't say she was good or bad, but he did say that what the court's done, he thought was a drastic measure, and he questioned whether or not it was the right move. So yeah, I didn't watch it. We all know she needs an attorney, but I have zero sympathy for her. Ooh, sympathetic? No way. I don't understand people sometimes, girl.
Girl, please.
Oh, wow. I didn't know he visited her. I don't understand how this all became about Sarah. You don't even hear George's name brought up anywhere. And I think that's totally unfair because it's Florida versus Sarah Boone right now. You'll hear tons about him when it comes to victim impact statements, everybody.
And that's when he gets his 5 minutes and everybody forgets him.
No, that's not nice. But
I mean,
this is Florida versus Sarah Boone.
I understand.
This is her time. Was he sympathetic to her needing a lawyer or sympathetic to her innocence? Because if it's the former, then that's not necessarily a bad thing. Oh, wow, someone who's actually critical thinking. That's cool. That sounds like what I saw, but it was mentor lawyer. What did you see? I never liked that guy. Oh my God, what happened? And what did he say? Spill it. Can't remember, but I think true crime were the first 2 words. I saw his comments under another video and went to his channel. I saw 3 videos. Oh wow, there's 3? I've only reacted to 1. George's family probably want to be left the hell alone. High-profile murderers and lawyers looking for that 15 minutes of fame always find each other like magnets. Oh, it's really gross what YouTubers will do for clicks and attention. Okay, well, you're on Court TV. You're commenting on Court TV's video, who, by the way, now have memberships.
Sweetie, princess, I promise you, what he has done is in the 1% top of classiness as far as what YouTubers will do for clicks.
Oh man,
we are whores. And Helen and I, in my opinion, are not nearly as whorish as we could be.
Oh, we could whore ourselves to death. But here's the thing, right? What he did got about 5% of the views that the rest of his videos on his channel do. He lost subscribers over it, but he did it anyway. He did it for similar reasons that I'm going down this route here, because I don't think that what's happening is justice. I don't like it. If I wanted to, I could just make fun of her like everybody else. And I don't, because I just don't like what's happening to her. I just don't. I just think it's shit. So I couldn't give a fuck. I'm so sick of people sucking the dick of the state all the time. Sorry about my language. So sick of it.
Yeah.
So sick of people buying the stories.
My ears are not garbage cans. Thank you.
So sick of people buying the same story as everybody else all the time, just because she's funny or she's, you know, annoying or whatever. She still has a right to a fair trial. It's as simple as that. I'm so over it. I saw the video, but it's interesting Sarah hasn't mentioned him in her name dropping. I wonder if he really went. Oh, you think he was lying?
Kurt also mentioned somebody contacted him
Mm-hmm.
about repping Sarah, so I don't know if it was him, but it was around the same time.
Here's someone with a brain. It's okay for any lawyer to help her get a fair trial, and everyone's hate for that needs to quell. That's a good word. I respect those who volunteer to help her out. There's got to be someone she can trust for advice on procedure only. I think she will be open to that. Let the prosecutor prove the case. She may get manslaughter and a lesser sentence if evidence can't prove intent to murder since she was stupid drunk. We will need to settle for that. Oh wow, 11 people agreed? Amazing. He didn't visit her. It was a skit with a woman wearing a wig.
Wait. He visited Mo?
Thank you for posting this. Okay, you read this one?
Thank you for posting this. I was so mad when I saw that. I trembled and unsubscribed him because I found that unsubscribe button and clicked it and felt so satisfied. What a ridiculous thing to do. It's almost as silly as unsubscribing from someone. Notice how he turned the comments off for it as well. Sleazy move. Grody. She is a total monster. And if it was his brother she did this to, he would think twice about a visit. People are hippos. Quits.
Aren't they? People are hypocrites because you know what? If this was your brother or your sister who was being fucked over by the court, fucked over by the state, you would think differently. But no. Hello, Lord of the Pancakes. Who's Josh? Josh chose to get into
Kiwi
the suitcase.
Farms, Josh.
Oh, okay. I thought you meant Meme for a second. I don't think Meme would fit in the suitcase. I don't think there's a suitcase on earth that would fit Josh. John, you gifted 5 excited utterance memberships. You're so awesome. Can you read them out, please, Dolly?
Yeah. Gina Jelia. That's a tough one. Kim S. Radiomi. And Irate Unicorn. Ooh.
Thank you so much, John. You're so awesome. You know I love gifted memberships. They're the best gift because the channel gets a gift, the people in chat get a gift, and it's just so generous of you. Thank you. Thank you. Or George or whatever his name is. Who's George? Oh okay, you got it's not Josh, it's George. Lord of the Pancakes is George. And thank you for being here, Lord of the Pancakes. How are you? Beautiful waterfall. Did you know everything?
Good
Can you
Lord.
Can you come back every stream, please?
You're like an encyclopedic ball of fire.
You are. You're just like a boonophile. Mental lawyer also did a skit pretending he was Jose Baez. Really? Jose Baez is our favorite, by the way.
He is.
We love Jose Baez. What? So he did a skit pretending he was Jose Baez meeting with Sarah. Okay, we didn't know that. That's a little bit off. Okay. So maybe I don't know about that. Found the unsub but can't find sorry, Snivels.
I thought my Valley Girl impression was cringe.
Okay.
Not you, Snivels.
The skit is very goofy.
Okay.
So okay, I'll go have a look.
I won't judge it pre-hand.
Yeah. So that makes this a negligent homicide case, not a first-degree murder. Yes. This is what I'm saying.
Yeah, I've said manslaughter from day one.
Is negligent homicide the same as manslaughter?
I think it's similar, kind of.
Well, it's not a life sentence, is it?
No, it's still up there, but yeah, I've said this from the first time I was on stream. On a stream that has now been taken down.
A stream that's now been taken down?
Because, well, I'll tell you later.
Okay. Okay, because I said that I restreamed it, and that's because I care about due process. And this person's gone, oh, this is the person who originally posted about it.
Like, wow. Are you like serious? Grody. I think you need to like do some more research seriously on this case because like you don't know anything. Sarah Boone's rights to a fair trial have like in no way been violated. Grody. Apparently you are as gullible and easily manipulated by Sarah Boone as mentor lawyer. Like, Grody, gag me with a spoon, girl. Do you know whose rights were violated in this case? Like a suitcase? Jorge Torres, girl. Those who you should be crying for, and Jorge, and I'm just going to go ahead and misspell it as Torre, 3 children who mentor lawyer should be spending his spare time helping if he wants to do charity work.
Oh, God.
Ugh.
I don't think
Truth 17, John 17. Justice.
Justice. Okay. I'll say it. I've said it before, and I'll say it again. Even if we are to accept that the court may have made the right call in denying her a further public defender, if the court's covered its ass with all of the case law and the ruling, la 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 la, if we cut it off right there and we go, fine, okay, sure, she's forfeited her right to a public defender. From here on in, how on God's green earth do you think she's going to get a fair trial now? How on God's green earth? What's happening right now with her due process right now? It's up shit creek without a certain paddle. Right? Look at what's happening to her now. Look at it. She got a laptop that's not even getting charged up. She's got no printer. She's got no apps on her damn laptop. She's got no phone. Right? She's got nothing. How can she prepare for trial? It's 60 days away. She has been absolutely hamstrung by the state and by the court. Like, they even argued against her having bloody shackles taken off. Now I get it. She didn't specify clearly what that motion was about. But come on. From here on in, how is she going to have a fair trial? I don't get it. I don't see it. Not possible. It's what's happening, so let's get on with the trial. Oh, man. You've gone pro se? Really, Brittany? In this short of a period, though, and incarcerated? I think it's the incarcerated thing that's the problem. I think they should, honestly, if they really wanted to cover their butt and make sure that she doesn't have an appellate issue in regard to her Sixth Amendment right to a fair trial, they should let her out on bond with an ankle bracelet, and they should give her a continuance so that she has a really good shot at representing herself now. Because I don't think there's any evidence that she's a flight risk or B, a danger to society. Yeah. Okay, really going now. Get ready to go. Okay. Looked up the laws on your phone. You had 30 days notice, but you weren't in. Sorry to ask you a personal question, but you weren't incarcerated.
I assume it wasn't a murder trial.
Yeah. Well done, though, Brittany.
It's still impressive. No, yeah, I give you a lot of credit for that. Yeah.
Yeah, well done.
I'm kind of jealous.
Yeah. No, I wouldn't have wanted to be in your situation.
Well, I've always wanted to go pro se, so.
Really?
Yeah. Oh, yeah. Oh, well, maybe not that, Brittany.
You were
but-
in jail and then you went out on bond. Okay,
Oh,
interesting.
okay. That's still impressive,
Wow.
though.
She was
job.
told this is where her behavior was leading her, and here we are. But
Yes.
that's not the point. So I'm going to accept that this is where she's at, but how now is she going to receive a fair trial at this point, leading towards 60, not even 60 days left now, when she is stuck in this situation with such limited resources? Not sure how that's going to work. She's going to be in and out of her head really soon. She doesn't understand the rules of evidence. Yes. She doesn't understand the rules of evidence, and there's a lot. Yeah. Okay. All right. Got to get going, guys. Now, tomorrow, 4 p.m. Eastern, Hearsay for Days. Oh, hey, Melissa Simon. That's all right. Hearsay for Days is 4 p.m. Eastern tomorrow. Yes, Boone is on the agenda. Lots of people have been chatting about Boone on the Twitters, etc. So that's tomorrow. If you're not familiar with Hearsay for Days, I know we've had a lot of new people this week. What we do is we look at what the people are saying. So not so much what people like Dali and I are saying or the streamers, etc. are saying. We do things kind of like this, like we get up comments from social media, and we look at the comments, we read them out, we discuss them. So, and we try and get out different points of view. So not just our point of view, other people's points of view. So yes, Sarah Boone is one of the topics. The other topic that we're looking at this week is Nick Recator. So the Recator Fest, he got his kids back. Yay! So people have different views on that one. Some people are very happy about it. Some people aren't too sure. So yes, we're going to be looking at that one, and we're going to have some surprise things this week because you know what? There hasn't been any big trials or anything in the Twitterverse and the YouTubeverse, but there's been some little things that have popped up. So I am open. I'm going to put a poll up at the beginning of the stream and say, would you like to chat about this, chat about this, chat about this? And people can decide what they would like me to bring up, because I'll have a few different things that we can chat about. So we'll play a little bit of a game, and we'll do some, some chat interaction as to what we discuss. So Hearsay for Days, 4 p.m. Eastern tomorrow. Sarah Boone, Nick Recator, and other trending topics. Woohoo! That's loaded too. Got visitation of his kids and full parental rights back. I know it's loaded, but I gotta say I'm on Team Kids. Team Kids, whatever makes the kids happy and it is good for them is what. That's the side I'm on. So yes, set your notifications. Leave a like here for Hearsay for Days. Oh, lovely. Okay, thank you guys. It's been a longer stream than I thought it was going to be. Thank you for hanging in there, everybody. I really appreciate all of your points of view. And that's it. There will be more Boone throughout the week. No question. And also, if you didn't notice earlier, I posted something about Coburger. I'm starting a series of Coburger streams late at night. And the first one is going to be on Wednesday at 9 p.m. with the lovely Kathy from the Indie Zone. She knows about as much as there is to know about the documents in the Idaho 4 case. She does wonderful little under 5-minute podcasts. I will start sharing them with you between now and then. So yeah, she's joining me 9 p.m. on Wednesday. See you guys tomorrow, 4 p.m. Eastern, and we have time now to play my little outro song. Remember, invest in the oppressed.
I love your waterfall.
I love it. Thank you for being here. So good to have you. All righty, where's my song?
I see it.
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Donnie and she dances sometimes. The words are always so loud.
Dare step on my computer.